Hello and welcome everyone to the Wall Street Blockchain Alliance's latest global webinar. So you want to be a special purpose broker dealer. Thank you all for being here. Before we begin, our usual disclaimers, please do keep in mind that everything discussed should not be considered accounting, investment, legal, or tax advice, and that our opinions or what we discuss are our opinions only and don't necessarily reflect the opinions of the Wall Street Blockchain Alliance or our respective firms. We've got a great lineup of people here. Thank you all again for joining us. This session is being recorded. Everyone will be in listen-only mode. We are waiting for one more panelist. We'll bring her on board as soon as we can. And then obviously we have the Q&A button available for you. If you have questions for our brilliant panelists, please do add them to the Q&A box and we will address them later on. Ron Quaranta here, chair of the Wall Street Blockchain Alliance. I want to give our wonderful panelists an opportunity in a few moments to say hello and to talk about the work they do. Tiffany, why don't we start with you? Please introduce yourself to the group.
Thanks, Ron. So my name is Tiffany Smith. I'm a partner at WilmerHale in the securities broker-dealer practice, which is very much on par for this discussion. Prior to starting to work with blockchain and cryptocurrency companies, my practice focused on really just helping securities firms register as broker-dealers and think about the rules that apply to broker-dealers. And now I lead one of the co-chairs of our blockchain and cryptocurrency working group. So happy to be here and share your thoughts.
Tiffany, thanks for joining. The one, the only Annemarie Tierney, please say hello.
Hello. Hi, I'm Annemarie Tierney. I am the founder and principal of a strategic consulting firm called Liquid Advisors. We work with a wide range of companies, broker dealers, investment funds, and other types of regulated businesses in the digital asset space and the traditional space. And we're happy to be, very, very happy to be here today with my friends.
Annemarie, good to see you. It's been too long, dear friend. And finally, Mr. Adam Goldberg. How are you, buddy?
Hi. Hi, everyone. Hopefully most of you guys know me before. My name is Adam Goldberg, and I'm the regulatory subject matter expert for our enterprise solutions group at S&P Market Intelligence. In that role, it's my job to monitor kind of any new regulations that would affect our businesses or our clients. So crypto and digital assets has been squarely within my portfolio, and we are actively both engaged with certain crypto firms and digital asset firms, but also many of the traditional firms that are participating in the crypto and digital asset market and looking to expand and looking to see which ways we can use our existing products or develop new products to help them kind of meet their regulatory needs.
Adam, good to see you, buddy. And for everyone in the audience, Adam is also stuck with me and our dear friend Dina Ellis for our regular recurring monthly policy updates. So it's good to have the three of you with us. I know Josh will be joining us as soon as she can. Tiffany, I'd like to start with you. The topic is special purpose broker dealers, and I feel like this kind of acronym SPBD has been thrown around for a little bit. Give us the foundation and overview. What are we talking about when we talk about a special purpose broker dealer? And really, how did we get to this point? What is based on from a customer protection perspective?
Yeah, thanks, Ron. So happy to address that. So I think because it's so elusive, there's only one firm that has this license. Folks think about this as being like the license for a crypto firm, but it's actually a bit different. So the history is that broker dealers need to comply with a rule called the Customer Protection Rule, Rule 15C33, when they have custody over client assets. And that rule requires broker dealers to have to maintain physical possession and control over the assets. And when you first started having broker dealers, and this goes back to 2017, we were really talking about traditional firms that wanted to trade securities on the blockchain. So I'm not talking about crypto. I'm really at the market there. I'm talking about this time during the market, and Annemarie knows this very well because we talk about this. It was really, tokenized Reg D offerings, things that people are calling real world assets today, or RWA. And so during that time, because of the way the customer protection rule worked, there were questions from the SEC and FINRA about how a broker-dealer could have possession and control over digital asset securities. So there was a bunch of firms during that time that wanted to register as broker-dealers and actually have custody over these assets. And because of the questions, first we had a joint statement from the SEC and FINRA, which talked about all of the questions as to how a broker-dealer could have custody and control over digital asset security. And that jointment came out in 2019. And it talked about both all of the questions about how you can comply with this rule, and it also talked about certain business models that were non-custodial. And that set the foundation for a lot of these broker-dealers and ATSs that allow the trading using blockchain, but they actually don't have custody. So you might see a bunch of ATSs out there that say, hey, we offer, security token offerings or digital asset offerings. They're all legal, they're all compliant, but what they don't have is the ability to have custody over the assets. And so based on that, you had, so that was in 2019. In 2020, in September 2020, you had a no action letter that came out, which was called the 3-step no action letter for an ATS. And it talked about how an ATS that traded digital asset securities could, settle the transaction essentially using these 3 steps, which allowed it to facilitate transactions, but again, did not have custody over the digital asset securities. And then that resulted in, the next year having the Special Purpose Broker-Dealer Commission statement. And what that is, came out in December 2020, published and became effective in 2021, but it sets a foundation for a broker-dealer to actually have custody over digital asset securities. And that's how most broker-dealers operate today, and it facilitates like trading of digital asset securities in a way that's similar to the markets for digital assets, for traditional securities. All right, go ahead, Ron. So you're trying to jump in.
Much. I want to welcome Josh to the panel. Josh, thanks for joining us. Annemarie, when you and I and Josh did prep yesterday, and as Tiffany started, I see you were acknowledging some of her points and agreeing. I want to open the Pandora's box here a little bit when we talk about special purpose broker dealers, and then I want to open it up to Adam and Josh. Certainly, I'm going to ask a dumb question, Annemarie. How did everything crypto get wrapped up into special purpose broker dealers, and how did that progression happen?
So I think that's a loaded question. I think that, Tiffany did a great job setting the stage. And back in the time frame that Tiffany's talking about, I was the chief strategy officer and general counsel of one of these platforms. It's called Templum. And back then, we were a registered broker-dealer alternative trading system, and our broker-dealer approvals, or our description, at least on broker checks, that we were approved to do private placements on unregistered securities and secondary transactions and unregistered securities, including in represented on a blockchain. So, and in my mind, that's just technology, right? So Delaware allows representation of securities in blockchain certificated format or uncertificated, like traditional book entry. And it's just technology. And what started happening was other broker dealers who wanted to facilitate secondary trading on unregistered securities saw the benefit of blockchain in facilitating secondary trading. And other broker dealers were trying to get the FINRA to give them approval sets that included blockchain in the descriptor or digital asset securities in the descriptor. And these were intentionally digital asset securities, right? Borrowing a phrase from our good friend Lewis Cohen, they were not crypto, they were not tokens, they were literally equity securities represented on a blockchain, common stock, preferred stock, whatever. And FINRA refused to allow approvals of applications at the time if the word digital or blockchain was in an application. And so they kind of, and Tiffany, you and Josh, you may have, experience with clients there as well, but I kept seeing friends of mine trying to get FINRA to give approvals that were similar to what Templum had, and they were just told no. If the word digital or blockchain is in your application, we're not approving it. And that just made absolutely no sense. And they started conflating digital asset securities, which are clearly just securities represented on a blockchain, with crypto. And so as they moved towards the special purpose broker dealer safe harbor, you had more and more broker dealers saying, we want to custody digital asset securities that are represented in blockchain. And again, because the SEC was conflating all these assets into kind of one amalgamated problem area, they started saying, broker dealers that want to participate around digital asset securities have to do all these extra steps. And one of the things that we talked about on our prep call was, before I was at Templum, I was with what used to be Second Market Holdings, and we were trading all kinds of unregistered securities, all kinds of asset classes. And then I was the chief strategy officer at Nasdaq Private Market, and we transacted billions and billions of dollars of private company stock in secondary transactions, either through just the broker dealer or through an ATS, and never had an issue with FINRA, never had an issue with custody of anything, never had an issue of record keeping issues or excuse me, or anything. It's only when the word blockchain came in that they started raising questions. And at the time the special purpose broker dealer safe harbor came out, it was, in my mind, clearly regulation by technology. It was clearly the SEC drawing a line in the sand saying, if you're touching digital, you have to, and Tiffany made the point about this 3-step no action letter, right? It just included things that made no sense. These just broker dealers operating the way they always had in a very well-regulated space, all of a sudden having to jump through all these additional hoops, all these issuers having to, bring on all these additional costs like a registered transfer agent for no clear additional investor benefit. So to my mind, the safe harbor was problematic from the beginning. It was issued, it was a standalone safe harbor. It was never subject to public comment. It was never subject to industry input. Significant numbers of comment letters were submitted. No changes were ever made. And now we're 3.5 years into a 5-year safe harbor. Mum's the word from the SEC. To Tiffany's point, only one company's been granted this elusive star of distinction, or whatever you want to call it. And nobody knows what happens after the 5 years. Nobody knows whether or not it'll be extended. Nobody knows whether it's going to be supplanted by actual rulemaking. But it's a really problematic framework based purely on the nature of the technology used to represent the security. That's the subject of the transaction. But I don't, as we said earlier, I don't have strong opinions on this one, Ron.
Annemarie, understood, and I appreciate your perspectives.
And
Adam,
these are completely my views and the views of Liquid Advisor, which I am the 100% owner of. So yes.
got it. Adam, Josh, just wanted to pull you into the conversation. Tiffany and Annemarie alluded to a couple of things that are really interesting. And when you threw the word blockchain into some of these, Annemarie, to your point, it suddenly became problematic. When we look at regulatory ambiguity, and I'm going to rip up the script here a little bit. Adam, let's start with you. Is that strategic on the part of the regulator, that kind of ambiguity and, oh, there's the word blockchain, we can't allow these to go through? And again, I want to give some deference and a little bit of credit to the regulator, but that ambiguity seems to be a tool almost. Tell me I'm wrong.
Well, first off, let me just backing on Annemarie's disclaimer, just so everyone knows these are my personal opinions and not behalf of S&P Global. I'll just give that disclaimer. But yes, I mean, I think the strategic ambiguity is part of it. I think one thing to look at the special purpose broker dealer, I guess, project, initiative, no action relief, whatever you want to call it. One thing to note is it's both industry and regulators that seemingly trying to solve a problem that they can't seem to find the solution to, which is how to actually allow compliant broker dealers in the FINRA SEC construct to trade digital assets, custody them, act like traditional, as Annemarie was saying. There may be nothing novel about a digital asset security. It may be a traditional security, such as an equity on something that we know exists, or a bond. It is something that operates in the physical world. It has rules around it. We have broker dealers. We have FINRA, who is the industry self-regulator of those entities. The SEC then additionally oversees them and has additional rules. And the question always from industry is, we would like to trade these assets. We think they are permissible under the current rules, as Annemarie says, because we don't view them as having any unique characteristics outside of the technology being used to where they are. What is the framework in which we can trade them? So this special purpose broker dealer concept came up, and I was like, well, is this the framework we could use? But the problem is, the answer basically industry has gotten is no, because the only special purpose broker dealer that has been approved is one firm, and they're a new firm, so their approval really doesn't impact all the existing broker dealers who said that they are interested in doing this kind of activity, because they still can't get approved for their own special purpose broker dealer status. It's really just for this new entity. And this new entity is not really even trading yet the assets they say they're going to custody. So as Annemarie says, we're kind of 3 years down this 5-year road, and we don't even have a use case for the one that is approved. So I would say the ambiguity is part of it, and something that regulators have used, because at least in the previous years, there has been a general unease from the Biden administration in trying to allow crypto and digital assets to go more into the traditional space. Obviously, SAB 121 plays a big role, which doesn't allow firms traditionally to custody these assets, and they would have to have a very adverse capital treatment, which really makes it unlikely that almost any of the large traditional firms can custody digital assets. You also have most of the major players in the market are regulated by the Office of Comptroller of Currency, the OCC. They need to have pre-clearance now before they do anything related to digital or crypto or digital assets, which means they literally have to go to the regulator and say, can I do this? And to my knowledge, I don't think the OCC has granted any activity in the area. So that again serves as another block. So yes, I think it can be seen in that light.
Adam, thanks so much. Josh, let's pull you into this conversation. Give us your perspectives on that. And I want to expand upon that a little bit if I could. Everyone's kind of referenced the one entity that's been approved, but we also have publicly heard about other entities that have applied and gotten nowhere. Why is that?
So Ron, it's a great question. And first, I just want to apologize that I joined a bit late. I was having some technical difficulties. So apologies if I retread anything that Tiffany mentioned during the introduction and otherwise. Also, all caveats apply. These are just my views, not anyone else's necessarily. So Ron, before delving right into that, I just want to emphasize one thing, which is that this was supposed to be a safe harbor, right? This was supposed to be something saying like, okay, you're using good efforts, right? This is something that was supposed to help move forward. And in fact, in the policy statement, the SEC was talking about, that it would try to, encourage innovation around the application of the customer protection rule to digital asset securities, right? This was something that was supposed to help and liberalize things a bit, right? To those actors who were trying to comply. I think as you've heard, and as we'll continue to hear, it's really been a logjam. And I think it's had some bizarre results, which I can talk about in a second. But as to what you were saying about the multiple parties that we've heard of, including public companies, where they have said publicly that they engaged in multiple meetings over significant periods of time, trying to comply, and there appeared to be no path forward. And, these are regulated entities, presumably trying to just do the right thing, just come in and register, so to speak. I've also had heard, just from friends who represented certain folks, I'll keep it vague, that when they began to talk about applications for special purpose broker dealer, they were often said, oh, well, it's still in the comment period, to which they said the 5-year comment period. So I think, why is this happening? I think it is, as Adam and Annemarie, and I'm sure Tiffany as well, have suggested, although let me not speak for you, Tiffany, since I wasn't there to hear it. I think it's just to hold back digital assets from going more mainstream in the first instance. But also we have to remember, when this was introduced, as Annemarie and others have talked about, it was a different time. This is before Gary Gensler saying every digital asset is a security, and things like that. And so, as Annemarie noted, and perhaps others have noted, originally this was intended for intentional digital asset securities. And the bizarre result that we've ended up with is that actually now, sometimes in the market, those that may wish to introduce intentional digital asset securities are in the position of having to try and argue, oh, wait, this digital asset security, although a broad definition, it doesn't apply to us. It's intended to apply to crypto, because of the way, the headwinds have gone politically and from the regulator. And a similar thing, I would say, Adam mentioned SAB 121. I think it's a similar conversation, where those who may wish to issue traditional digital asset securities on a blockchain are in a position of trying to say, hey, SEC, your beef is with crypto and not with traditional securities. So it's ended up as a bizarre result.
Josh, thanks so much. And again, for everyone in the audience, thank you so much for joining us. If you have questions for our great panelists, please put them in the Q&A. Annemarie, Tiffany, I'd like to pull you into this conversation. And I often have this discussion with Josh and Adam and others within the Wall Street Blockchain Alliance. It almost seems, when we look at investor protections, some of the regulatory actions, and this is not to bash a particular regulator, seem to do the opposite. They seem to push participants to a realm where it's difficult to comply, where the traditional TradFi participants are pretty used to complying. I guess the question becomes, and Annemarie, let's start with you. When regulators make these kind of decisions, are they thinking about that market impact, or is that kind of market impact not part of the calculus? Annemarie, what are your thoughts?
So I think what's fascinating with this, we've talked about this was not a rulemaking proposal. Right. This was not rules that went out for public comment with a cost benefit analysis. This was not something where the staff took input. I don't think anybody in the industry, that at least that I know of, interacted with the staff when they put this safe harbor out. And Josh, to your comment, there's no comment period. This was out. It was immediately effective, or effective like fairly quickly, 5 years and done. One of the comments that was raised multiple times by multiple commenters is, what investor are you trying to keep safe here, and how does this make people safer? The traditional rails for transactions on registered securities work, right? There was no wrongdoing, no harm being shown to be occurring around transactions in intentional digital asset securities. In fact, I think that the special purpose broker-dealer safe harbor muddied the waters, right? Because it includes all this language like broker-dealers need to do an analysis of a digital asset, decide if it's a security. Like, that's not a broker-dealer traditional activity to make a decision about whether a digital asset security or a security that they're trading is in fact a security. Of course, it's a security. Broker-dealers can only transact in security. So it started begging into consideration like what in fact the business was. And I think another point in the broker-dealers, the special purpose broker-dealer safe harbor, and correct me if I'm wrong, but it was, if you're transacting in digital asset securities, you could not transact in traditionally represented securities. And that made absolutely no sense to me. Like, why would you say you have to have one broker-dealer to transact in traditional broker-dealer, traditionally represented securities, and one in digital asset securities? It makes absolutely no sense. And most of the businesses back then, and I think this is probably true of most of your clients back then, Tiffany, we had a business where we did a private placement for an issuer, and 12 months later, when the private placement was issuer securities has been outstanding under Rule 144, we were going to have an alternative trading system that traded those securities amongst investors. Generally, we were keeping them to accredited investors, but we're going to have a really efficient alternative trading system with all this smart contract kind of whitelisting of compliance features built in. And that made so much sense. It was going to facilitate secondary trading. It was going to allow issuers to know who their buyers were. It made all this sense. And somehow that terrified the SEC. And I just didn't understand how increased compliance and increased visibility and increased transparency around secondary transactions triggered something, because the word blockchain, that said, okay, if you're going to do that, all this other stuff has to apply. That doesn't apply if you're not in the blockchain space. But so again, we never understood what investors they were trying to protect. Most of the transactions in unregistered securities, you have to be an accredited investor to buy them in the secondary transactions. These are not retail investors that are being solicited or sold to. So we never understood who's the investor being protected. There's no cost benefit analysis in this, to my point. There's no context that this is there's no basis for the imposition of these fairly significant and costly burdens on a broker dealer. And again, nothing ever came out after the safe harbor was published to even address or contemplate the feedback that was provided.
Annemarie, thanks so much. Go ahead, Josh.
May I just jump in for a second? Just to put for those, listening, because I realize it might sound confusing that, okay, this was out there, it was a rulemaking, it wasn't a real rulemaking rather, yeah. But this, and kind of pulling together what I was saying about the comment period, which didn't exist in the traditional sense. If you look at the policy statement, there's this weird statement where it has the effective date, and under it, it says you may submit comments at any time throughout the 5-year term of this commission statement, which is so backwards to
Right.
Annemarie's point, right? But it also allows the regulator to then say, hey, well, it's still in the comment period, right? Like, what do you mean? Like, we don't know exactly what we're doing here. And so I think that is, it's unfortunate that it's been used that way, but it also, I mean, if we look at the introduction of SAB 121 and what the USGAO said about that being an improperly passed rule, I mean, there's a lot of things that one potentially could say about this.
Well, what's also fascinating is, after the fact, we heard from, people in trading and markets at the time and commissioners like this, it took a huge effort to get this out to help the market, right? This was the best they could get out under Clayton at the time. And the market was asking for some kind of guidance, asking for some sort of answer. This is the best that they could do. And that was very shocking to me, that the best they could do was not a rule proposal. It was a 5-year safe harbor that didn't contemplate any market input. But, I don't criticize the staff. I know they do the best they can, but it was an unusual way to approach something, and kind of consistent, I think we'd all agree, with how the SEC has treated our industry, which is very little formal rulemaking, very little actual considered guidance, very little industry input into things that they put out. So kind of problematic.
Ron, can I just mention one?
I got to go to Tiffany because I want
Yeah,
to know.
sure.
Bear with me 2 seconds. Tiffany, weigh in on this, and I want to say something a bit cynical, but it might be cynical, but a 5-year comment period seems a bit of a cynical play on my part. But Tiffany, what are your thoughts?
So I'm gonna say something kind of controversial, since it's brought us back in time, right? So this is December 2020. Jay Clayton is still in office, that literally about to leave office, right? And so, one, I think both in the Clayton administration and Gensler administration, there's just general discomfort with blockchain technology. I think that's why we have different rules. But I do think that the intent behind the commission statement, just some more, we're calling this a safe harbor, but what it really is a commission level no action position, which is atypical. Typically what you have is a no action letter that's drafted by the staff, and it says it's a staff position and the commission can therefore disagree with it, right? So this is a statement by the commission, which is not common, and it has both a path to actually, become a special purpose broker dealer, as well as a comment period. And if you think about the administration during that time, they would put out first the joint statement, which then facilitated all of the broker dealers that wanted to use blockchain that were in queue for years, sometimes almost 2 years. That joint guidance in 2019 allowed them to get approved. And then you had the 3-step no action letter, which allowed ATSs for blockchain, for digital assets, to at least operate in some form. So I think because of the change in administration, this statement didn't actually operate in practice the way it was intended to. I don't think that it was actually supposed to be a elusive commission statement with only one firm receiving the release, 3 years later. I think instead it actually was meant to be helpful, but because of the change in administration, a different position was taken. And now we're looking at it and saying, well, what was the intent? But if you think about the timing, and you think even about, and Josh alluded to this too, the timing of this is all critical, because 2018 is when you have the Hinman speech. Keep in mind that it wasn't until Gensler came in office that all of a sudden we think ETH is a security, which ergo means that all of the other assets that behave like ETH are securities, right? And and basically changes our entire view, the entire industry, right? So all of the timing is important, and it's important to keep the change of administration in place and question whether or not this is what Clayton and the other commissioners at the time had in mind, or instead we're in this weird position where you had Clayton's administration taking one position and then Gensler came in and took a different position.
Tiffany, thanks so much.
I mean, we did hear from FINRA, they did not have any interaction with the SEC on this statement. And for the SEC to put out rules that FINRA has to actually implement around approvals of broker-dealers, that seemed quite unusual as well to me.
Annemarie and Tiffany, thank you so much. Adam, I know you wanted to weigh in. Please go ahead.
Yeah, I mean, it's actually good Tiffany went first because it actually somewhat builds on her point where the staff and kind of the SEC, I don't fully appreciate kind of the change in regime, and that may have affected a lot of things. One thing to note is when this was issued and going forward in the aftermath, we were expected to get a custody rule from the SEC that defined digital assets, and actually the proposed rule actually had a definition of digital assets that the SEC seemingly was behind. And then when they actually released the final rule, they pulled out the definition of digital assets or any mention of it. So it seemed we were on this path to trying to get some clarity and rules of the road into how to operate. And then there was an intentional decision to pull back on that. Maybe they thought the regulations weren't ready. Maybe they weren't comfortable with them. Maybe the existing formulations didn't work, or notice and comment that they got back was making it more problematic. But I think it also has to be understood in that context, because at the end of the day, the special dealer purpose broker-dealer concept is about customer protection. It's about custody of the assets. And clearly, if you had some more guidance as to what custody is and means for digital assets, even what is the definition of digital assets according to the SEC, that might help resolve some of these discrepancies. But without that, we are left in this kind of murky situation we're involved in. And that's one of the reasons why this concept hasn't really taken off, because when the special purpose broker-dealer concept came on, okay, we thought just traditional securities that may be tokenized. Then it's okay, they might be ETH-backed securities on the blockchain, or they might actually be tokenized ETH. It kind of morphed, and one of the reasons it morphed is because there were not grounding definitions to say go this way or go that way. Actually, if anything, we got more ambiguity as time went on, which I think only further hurts the path of anyone trying to register or trying to utilize this concept, which is one of the reasons that I don't really think you've seen it take off, because at least as the framework is this, as Annemarie explained, it's not workable for a traditional broker-dealer, because no traditional broker-dealer is going to give up their ability to trade traditional securities to trade this amorphous definition of what could be a digital asset security, maybe that might be approved when you do your own analysis as to if it's a security. And really your only guidance as to what the SEC thinks is a security is a couple of filings in discrete cases where they have identified certain coins that they say are securities. And that's really about it. Even up until that point, ETH hasn't made that list in many cases. So you're still in this gray area, even around the one asset class that this may be designed to trade this special form. So it is very difficult. As I said, it's like we've gotten even more ambiguity as time has gone on rather than more clarity.
For the record, every
Yeah.
time someone says the word ambiguity, my brain places the word. Adam, Josh, go ahead. I'm sorry.
Yeah, I was just going to say, in terms of how one might look at the term digital asset, like if you look into the statement that they provided at the time of their policy statement, there is a footnote, and I think, but again, it's not very helpful, right? It's exceedingly broad, but then it suggests that there are other assets that are not securities. And I'll just read it. It says, for purpose of this statement, the term, quote, digital asset refers to an asset that is issued and or transferred using distributed ledger or blockchain technology, including but not limited to so-called virtual currencies, coins, and tokens. The focus of the statement is digital assets that rely on cryptographic protocols. A digital asset may or may not meet the definition of a security under the federal securities laws. And then it has a cite. And it says, as used in this statement, a digital asset security means a digital asset that meets the definition of a security under the federal securities laws. A digital asset that is not a security is referred to herein as a non-security digital asset. So what's really tough, and I think this we've been hearing from a lot of the applicants, is that, okay, well, which ones are securities? And it's a case by case, it's facts and circumstances, as we've heard 1,000 times. And then to our friend Lewis Cohen and others, the question of whether the digital asset, if it's not an intentional security, whether that digital asset itself is ever a security, or whether it's just part of an investment contract, right? The object But yeah, I mean, I agree with Adam about what he was saying about the lack of clarity.
Well,
I
to
feel
use a
Annemarie
term.
wanting to add on to that, Josh. Go ahead, Annemarie.
I was gonna say, like, one of the questions that I had at the time is, what if you have 10 broker-dealers and they reach different conclusions around the same asset? Okay, so everybody has to do an analysis, right? So we have, we've seen 3 crypto exchanges or 4 crypto exchanges or however many now have had SEC enforcement actions brought against them with different tokens deemed to be securities. Now there's overlap between the lists of across the exchanges, but they're not the same list on every exchange. And those exchanges have had, highly qualified lawyers and experts do deep dive analysis on these tokens to make a determination they're not securities. Those are deep pocketed crypto exchanges. How does a broker dealer that's operating have the same deep pockets as a Coinbase, right? Or potentially a Binance US or a Kraken to do that level of analysis? And what happens if they get it wrong? They're having enforcement come down their throats the same way. And then what happens if like three broker dealers create a different conclusion? We've seen the one approved special purpose broker dealer decide that ETH is a security. Well, no one else, including the SEC, has deemed ETH a security and in any official capacity, right? So in none of these enforcement actions has the SEC said ETH is a security. But now you have a broker dealer saying ETH is a security that they're going to custody. What is the implication of that kind of one-off analysis that something's a security? I find that very problematic, that multiple broker dealers can make multiple different analysis and multiple different conclusions. And how does that impact the issuer or the project or allocator of that original investment contract and the token affiliated associated with that project? Like, these are really, really problematic, outcomes created by, this kind of, I think, language that probably was unintentional.
Annemarie, thanks so much. And again, please do keep your questions coming in. Thank you all in the audience. Tiffany, let me go to you, and I'd love to ask what in my mind is probably a dumb question, so forgive me in advance, but you and Annemarie raised the fact that this special purpose broker dealer expires. I believe it's in 18 months, give or take. Dumb question, Tiffany, but what happens to all of the applicants who applied if this thing expires?
I mean, we know what we don't know. A number of applicants have mentioned that they are implying they are in a queue. So if the relief were to expire, it depends on what the SEC does next, right? Mm-hmm. So they can actually take, do a rulemaking or take action to make the commission statement permanent, right? And so that would mean most likely that the applicants could, complete the process and get whatever the permanent, relief guidance is. But if instead the SEC decided to, do nothing after the expiration, it would essentially mean that all of the firms that were in queue would, have no result, right? There would be nothing for them, no type of special purpose broker dealer authorization for them to get. But the most interesting thing is picking up something that Josh mentioned, is that this is no action, it's a no action position, right? So technically you can operate without this type of guidance. And so that's like a third variation. So long way of saying it kind of depends on what happens next from the SEC and how they decide to move forward with this commission statement.
Tiffany, thanks so much. Let me stay with you for 1 minute. And if Ron walked into your office one day, given the current state, I wouldn't do this to you, and said, I want to open a special purpose broker dealer. What's my first step? Well, to the extent you could discuss that, what would you advise?
Well, so the process is really a twofold process. This is why Annemarie's comments were relevant. Talking earlier about how the commission apparently didn't get input from FINRA when they came out with this commission statement. So to become a broker dealer, like from an SEC perspective, it's just essentially a notice file and call it Form BD. But the real work is becoming a member of FINRA, which is a self-regulatory organization. And the process to become a broker dealer like there's a process that everyone goes through. You need to have policies and procedures, you need to have licensed personnel, et cetera, et cetera. It's generally a 6-month process. The overlay with this is that you also, to get this special authorization, you need to actually comply with all the conditions in the release. And when I've talked to the defender staff about this, they're very strict about complying with all of the conditions to a T. And you also, and because this is commission guidance, anytime there's any type of interpretive question about whether or not some policy procedure is in compliance with the commission statement, FINRA has to go back and talk to the SEC, right, and get this type of guidance. And so I would advise you, like, one, what the mechanics are of the process, but also like make sure that you understood like the potential length of the process, and the fact that thus far there's only one firm that successfully has gotten through the process.
Tiffany, thanks so much. Adam, Annemarie, I'd like to pull you into this part of the dialogue. You know, when we look at the conditions for relief, let's put an optimistic hat on. We're going to do, XYZ company is going to do everything they can to comply with conditions of relief. And one of the things that really stuck out to me was, and I'm paraphrasing here, deep awareness of the security and operations, deep understanding of the technology. Annemarie, let me start with you and give it to Adam as well. Even in the most optimistic of circumstances, is that reasonable?
No. I'm being optimistic. I mean,
Why?
this is a broker dealer, right? That the business isn't to understand the technology underlying the assets that they want to trade, right? That's like saying, if I wanted to trade private company stock, I needed to understand the business of every company I was going to trade, right? I think you need to have a good understanding of blockchain technology, or the means that you're going to use for the trading of your own platform, the technology for your own platform. You have to understand that, right? Because you have to be able to explain that to FINRA, and you have to demonstrate that to FINRA. But like overall, I think, again, they're asking for a level of expertise, a level of expense, a level of compliance, a level of cost that's just not linked in a meaningful way to investor protection. I think that's what they're supposed to be doing. They can ask for things if there's a correlation to investor protection, but I don't see how they've shown that here.
Annemarie, thanks. Adam, please weigh in on that. And what I would add to that as well is, to Annemarie's point, you know, in the most optimistic of circumstances, even if you were able to explain the technology, and I don't mean this to sound as cynical as it's going to sound, would regulators get it?
Yeah, so I mean, so the way I try to view it is around the technology piece is there are certain other regulations that do require a certain familiarity with technology, and more this is for the facilitation of a control framework around them. One example comes to mind is regulations around algorithmic trading for swap dealers in your risk management program. If you're going to have any kind of algos that are trading, you do need to have some understanding of the technology, how they're going to trade. You need to do some testing to make sure that it's not going to kind of go haywire, that can act in a stress situation. But anytime you're adding requirements on kind of a special purpose or unique structure, it almost goes against kind of the goal of the structure anyway. That the structure should be to make these more like the traditional broker dealers and controls, and have a similar risk management framework for them. If you're adding additional steps, like making you be an expert in the technology underlying the digital asset, I think you want to be careful there, and you want to have some more into the level of knowledge you would need for existing requirements. As I said, let's say example, algorithmic trading for a swap dealer, rather than some unique requirement to fully understand like completely how blockchain technology works and completely how every single thing. I mean, at the end of the day, as Annemarie said, the goal of a broker dealer is to have assets available to match up sales and buys. That's the reason that's the purpose they serve in the market. Is they're supposed to be a middleman. They're supposed to match buyer and seller. They're supposed to have an inventory, so when buyer comes in and say, okay, I can sell it to you, and I'm going to have sellers on the other side that they're then going to buy it. It's supposed to kind of, it's an infrastructure piece of the market. And so yes, there's a certain knowledge requirement of the assets you're dealing with, of course. But some of the things that are being asked for, like determining whether or not it's a security, I think all of us at this table are going to have a hard time answering if the SEC thinks ETH is a security, because as I said, like the only guidance I have, if I really want to go to hard and fast guidance as to what's a security, what's not, is the filings where they've charged people and they've charged platforms that allow trading of ETH, and they have not identified ETH as a security. So what am I supposed to think there? I mean, they've taken tokens on platforms that are trading and said, these are securities. ETH is on that platform, and then they don't identify it, and then they won't answer to you whether or not it is a security. So making these kind of judgment calls can be very difficult, and even from this technology perspective, it's somewhat of an amorphous standard. Even the swap dealer regulation kind of gives you 4 components for algorithmic trading as to what your control framework needs to be for that. I think it would be much better to have specificity as to what does that knowledge, or how do you meet that knowledge requirement? What is the standard you're trying to meet? What are the controls you need to put in place, for example?
Adam, thanks so much. And it reminds me of one of the memes we had seen. I'm probably messing this up, but it was someone goes to the regulator and says, I don't think this is, is this a security? And why don't you tell us if you think it's a security? It's like, I don't think it's a security. What will you do? What do you think we're going to do? So it's just this, I get the point, Adam. Thank you so much. Josh, let me pull you into this as well. We've talked about FIT 21, and we can address that broadly here. We've talked about SEB 121. I want to ask Josh, not necessarily a politics question. I'll leave that for Adam and everyone else, but we've seen what I consider to be a pivot, at least from the administration's perspective, on crypto. Will that demur down to what we're seeing here around special purpose broker dealers? And kind of what are your thoughts on the next steps?
In terms of next steps, I'd like to think of that for a moment, but may I loop back to what you just asked in the prior question? Because there's something weird in the requirements that I always thought was a weird statement, but as I'm saying that, I will also think about what you just asked. So if you look at the policy statement, it says a 6th step the broker-dealer could take is to provide written disclosures to prospective customers about the risks of investing in or holding digital asset securities. Now listen to some of these, well, at least one of these disclosures that I think is a little bit weird. So it says the disclosures could include, among other matters, 1, a prominent disclosure explaining that digital asset securities may not be securities as defined in SIPA, the Securities Investor Protection Act, right? And in particular, digital asset securities that are investment contracts under the Howey test but are not registered with the Commission are excluded from SIPA's definition of securities, and thus the protections afforded to securities customers under SIPA may not apply with respect to those securities. Like, what? So I think that's one of the very curious things. I think in terms of what the administration's position will be with respect to this this safe harbor, I mean, I think if we look at what has been done with respect to the veto of the repeal of SAB 121, in my view, it seems that we are, at least I would imagine that at this point, especially given that there are a number of cases working their way through the courts, I don't think we're going to see the Biden administration speak out in any way or propose a change to this necessarily. It appears that given the past few weeks that there have been more positive statements about encouraging innovation. But I do believe personally that to the extent that we see big changes, I think that they may come from the SEC, from pressure from Congress and others, right? And also depending on how court cases come out. But I think in some ways it would potentially be a point of embarrassment, right, to Chair Gensler and the commission, right, to have this altogether struck down somehow. So I wonder whether there may be an appetite in the future, as I believe there may be an appetite in the future with respect to SAB 121 to potentially introduce something that looks different from the existing rule. But I think, or policy statement, but I don't think that it would be done in such a way, or I would imagine that it wouldn't be done in such a way that would concede that what was introduced previously was somehow flawed. Just personal views.
Gosh, thank you so much. I saw Annemarie's head shaking when you mentioned government and innovation. Annemarie, did you want to weigh in on that a little bit?
No, it's so troubling that the tone is changing because we're coming up to an election and the other candidates becoming, crypto enthusiasts, kind of, I would say, taking advantage of a gap, right? And taking advantage of a industry that's extremely frustrated and taking advantage of an industry that feels like the White House has been directed substantially in its policy towards our industry by Elizabeth Warren, and allowing Gensler to kind of do things in a way that's inconsistent, in my view, with SEC's traditional mandate of investor protection and capital formation. So I think it's problematic for the president to ignore the GAO's own determination that there should have been a rulemaking to decide that bipartisan support to repeal something that the GAO should said was, I'll use your kind word, Josh, flawed, and just say to repeal something at a congressional level that the SEC put out in a way that the GAO said was flawed would somehow bind the SEC from future activity. Similar, like it should not be allowed to do things like this. So I find that whole process super problematic. I find the White House decision to veto something and to put out a statement saying they're going to veto it before they actually knew where Congress is going to come out super problematic. I think the fact that the banks are probably pressuring an overturn of SAB 121 in part because of the approval of the spot Bitcoin ETFs and the fact that they're losing out on custody of an extremely popular asset class, Bitcoin. Right now, our eyes are open saying, wait a minute, like there are trillions of dollars flowing into this asset class and we can't custody it. It's not a security. Bitcoin's not a security, but we can't custody it. Like there's a lot of pressure coming in now from more traditional, institutional investors and asset class. So I think the whole thing's very problematic.
Annemarie, thanks so much. Tiffany, do you agree? And I guess in the context of, I think the Bitcoin spot ETFs are now over 30 billion, and the most legacy of TradFi firms, BlackRock is the largest of the spot Bitcoin ETFs, I think at 13 plus billion. Do you have the same opinion?
Yeah, no, I agree 100%. I know, one of the banking trade groups actually did send a letter right before the SAB 121 vote, I think urging the president not to veto it. So I agree. I think we're in a place where at the time this commission statement was proposed, at the time, even when SAB 121 was put out, we were in a completely different place. And now that there's more institutional adoption, I think that's why you're starting to see the trade winds shift a bit, that in it being an election. And so we'll see what happens in the coming months. But like all of this is why I always keep anchoring back to the time, because like things are really changing, dramatically just based on what the current environment is when various actions are taken by either the SEC or Congress.
Tiffany, thanks so much. Adam, let me pull you into this. You get stuck doing our policy update. It's always a privilege, and you and I have politics conversations. And I know we're veering a little bit off course. We're talking about SAB 21, but against the canvas of everything we spoke about from the administration perspective, give us your perspective on this. And I, in an election year, is the president vetoing a bill supported by his majority leader weird to you?
No. What would have been weirder is him allowing a CRA repeal. I would have to look back, but I cannot remember a time where a CRA repeal was allowed by a president of his own administration's rule. Usually the CRA is used from administration to repeal previous rulemakings from the last administration. And then a lot of times the president will agree to it by not vetoing it. One of the things said in the policy statement, the statement of administrative policy as to why they were vetoing, and also echoed in the veto statement, was they basically had to veto procedurally, because if they don't, then basically they lose the ability to write any rule around digital custody for a period of time. According to the CRA, basically it blocks any new rulemaking the administration could do in a specific area if the rule that they passed in that area is then repealed and they allow it. What I do think is likely, because of, as you said, there were 60 votes in the Senate for this repeal. There was significant bipartisan majority in the House. Obviously, this is a important priority both for the crypto industry and the traditional financial industry. It's one of the parts of the industry that both go hand in hand, both support the ability of traditional firms to custody assets in a way that doesn't have such negative capital treatment. I do think there is a chance of, when the dust settles a little bit, maybe in a couple weeks, maybe next month, some modification to SAB 121. I think there is significant pushback. It obviously was originally released as a staff accounting bulletin, then it was determined to be a rule. The veto essentially preserves the continued authority of the SEC to issue staff accounting bulletins, which again would have been somewhat curtailed if they had agreed to the repeal. A lot of the goals of the repeal could be accomplished by, obviously, withdrawal of SAB 21. I don't think that's likely because that wasn't mentioned in the veto statement as a possibility. I believe if they were going to withdraw it, they would have given some indication in the veto statement. But the veto statement definitely did say they wanted to work with Congress. They heard the feedback. So I think what you could see, and again, it may be political, we're in an election year, trying to win over those votes. And obviously you have seen some more steps that are seen as industry friendly, such as the approval of the ETFs. And also, I'm wondering from kind of the SEC perspective, the Gensler perspective.
And
Right?
I'm going to interrupt you. They did not approve the ETFs.
No, they approved the S1 filing. They approved
No,
the
they approved
exchange
the
rule
rule
books. You're
changes.
absolutely right.
The
They approved
ETFs
this.
have not been approved.
Yes, the ETFs
Correct.
themselves have not. I spoke incorrectly. You're absolutely right. They approved changes to the rule books for where they would be traded to allow for their trading. They still have to approve the individual.
Correct.
But actually, getting on that point, I think one of the things you see in all these filings is that on almost every one of the filings, Coinbase is the custody agent. Is that what the SEC actually wants? Do they actually want to have a principal digital asset firm be the custody agent for all of these traditional exchange traded products? Would they not rather some more traditional firms, be it Fidelity custodying their own, be it BNY Mellon, the biggest custody agent in the world, be it State Street, who said they're getting into digital custody, another huge custody agent? It does it not make more sense for some of the more traditional custody players to have the ability? And honestly, with SAB 21, just the way it's created with their capital rules, because of other capital rules such as Basel III and the way they interact with SAB 21, you cannot, as a traditional institution, because you basically push your risk weighting for your entire firm into an area you're not allowed just by having a de minimis amount of digital assets. So that's why I do think there is area here for them to, let's say, give the crypto industry a win that may appeal to those voters, even if despite the repeal. So I think we have to see there, but that's my hope.
Adam, thanks so much. I just want to get to a question and then get closing comments and wrap it up. Really appreciate that, Adam. Shout out to Larry Miller, WSBA member. I'm going to read it out for the group. I'll let smarter people than I answer this. Would it be potentially helpful to leverage aspects of the 2022 amendments to UCC? Controllable electronic record under Article 12 is a digital token. Article 8 permits party to opt to a legal framework permitting CER to be securities entitlement. Why not urge the SEC to leverage this clarity? Annemarie, I'm going to start with you on that. Why?
I have a night terrors about UCC law. My night terror is that I failed commercial transactions in law school. It didn't actually graduate, so anything about the UCC, I kind of go into like a coma. So I'm going to pass that on.
And I'm going to throw that out for
Adam
or Josh. Thanks, Annemarie.
Go ahead, Josh.
Okay, so I mean, I think it's an interesting idea, certainly. For those who don't know, like the new proposed Article 12, would relate to essentially secured transactions, right, involving digital assets or controllable electronic records. So it's amendments that make some clarification, including to terms like, money, right, and making sure that there's carve out, so that digital assets are not considered, quote, money unless they're falling into certain specific requirements. So for example, just as a little bit of background, like if El Salvador, right, adopts Bitcoin as a currency, right, it is not still money because it wasn't issued by El Salvador, for example. But at a larger level, while it is potentially helpful that there are these rules, I think the bigger question that it doesn't necessarily get to in my mind is the question of, is it a security? Right? And I think that is the key question. And that is what kind of drives this in terms of whether you need this special purpose broker-dealer, whether you need a broker-dealer at all, right? And so I do think that from a technical perspective, having, this kind of definition is helpful for secured transactions. I don't know. I think the real question is getting clarity, like maybe we would get through, I know it's, there are arguments against it and there are arguments for it, but for example, something like Fit 21 or something like the previously introduced Lemastila brand, something like that, where you do have some kind of dividing line between when you have a security or a non-security. I think that is really the piece that needs to be focused on and not necessarily the definition of something as a controllable electronic record.
Josh, thanks so much. Really appreciate that. Larry and the rest of the audience, hope that makes sense. Tiffany, I want to give you the last word. I'm going to ask you to put your Nostradamus hat on. Does SPBDs get better or do they go away?
Oh, that's a hard question. It depends on the election. If there's a change in administration, I think it goes away. If there's not a change in administration, then I think that they get better and you see more funds.
Tiffany, thank you so much. Tiffany, Annemarie, Adam, Josh, we are out of time. Thank you all. You guys are brilliant as always. And I always learn from talking to each and every one of you. For everyone in the audience, again, thank you for joining us. If you have questions for our panelists, email us info@wsba.co. We will get to them and they will give you their thought leadership and scholarship. We'll leave it there. Again, to my four panelists, thank you so much. Really appreciate your time. Bye-bye.
Thanks, Ron.